All right. We are starting DC 2012084 Canterbury Cove LLC versus THB Construction LLC and Travis Bonney. Counsel, make your appearances.
Sean McCafferty and Ryan Owen on behalf of Canterbury Cove, and you can see in the Zoom room our client, Mr. Bart Reeder, and a witness, our expert witness, Johnny Holstead.
Scott Hayes and Maddie Hayes on behalf of THB Construction and Travis Boney.
All right, let's go ahead and get started. I've reviewed the documents that were submitted. Thank you for getting those to me. First thing I'd like to do is go ahead and try to pre-admit as many exhibits as we can to try to move this trial along as quickly as possible. I was provided a first admitted exhibit list by the plaintiffs, which contain exhibits 1 through, oh my goodness,
137.
1 through 137. Okay, wow, that's a lot. Any objections to 1 through, are you offering 1 through 137?
I am, Your Honor, with one caveat. 121 and 122 are demonstrative slides that we'll probably use, and I didn't finish those until the end, so I don't think Scott has them. So I'm not going to offer those right now, but we'll use them during the course of the trial, I think.
Any objection to the remainder of the exhibits, Mr. Hayes?
No objection. No objection.
All right. All the exhibits, other than the 2 that were listed, are admitted. Give me 1 second. Mark that. And you provided a copy of those exhibits to the court reporter?
I thought we had, Your Honor, but Mr. Hayes says that the Dropbox link that we sent, he did not get. So I'm trying to get in touch with my paralegal to make sure that actually did go out.
And Your Honor, just to provide context, I'm going to create a new link and send that over here in the next minute or 2.
Tony, are you able to download from a Dropbox?
Should be able to, yes.
Okay. Just make sure you send, Tony, can you include your email address in the chat so that Mr. Owens can send the plaintiff's exhibits to you?
And Mr. Owen, if you can also on that email copy, it'll be mhayes@wslawpc.com.
Yep.
So she has access to it. So thank you.
Sorry about that, Scott. I thought that went out. I've been sitting here trying to send you a zip file. It's just too big.
Okay, but obviously we have all the exhibits in hard copy and all that, so it's
Great.
So the defendants have exhibits 1 through 8, which is a little bit less. Any objections to defendants 1 through 8?
The only objection, Your Honor, we have is to number 8, which is the attorney fee statements, and we filed yesterday afternoon a motion to exclude the defendant's attorney fee claim because they never designated experts or frankly produced these fee statements until yesterday afternoon. So I'll just make that objection and that motion now, and that's it.
Mr. Hayes, did you designate an attorney fee expert in your disclosures?
No, we did not, Your Honor. Again, I would say at this point there's been a request for fees, and at this point it wouldn't be a surprise on the amounts or the fact there would be a request and testimony as to attorney's fees.
I'll let in 1 through 7. We'll kind of address the issue of attorney's fees as we go on. So, all right. Any other pretrial matters we need to take care of before we start opening statements?
The only other issue, Your Honor, that I have, and I don't know how you want to address this, but yesterday we had our motion to compel with a request for sanctions. One of the sanctions we were requesting, given the lateness of the issue with respect to trial, was just a non-monetary sanction related to a finding a fact that would be essentially the analog of a adverse inference because they failed to produce documents related to the commingling of funds in the accounts at THB and the use of funds paid by Canterbury for other projects. And we don't need to take that up right now, but that's really the only other pretrial matter. And so I figured we'd just raise it and see how you wanted to handle it.
Okay, we'll deal with that as we go along.
Okay.
All righty, let's get started. I've read all the briefings, so But go ahead and give me you don't have to just regurgitate what's in the pleadings, but you can argue whatever you like.
All right, thank you, Your Honor. Permission, do I have permission to share screen, Your Honor?
Let me do that right now. Go ahead.
All right, thank you. Hopefully you can see that. Can you see that, Your Honor?
Yes.
Okay. I represent Canterbury Cove LLC. Canterbury Cove LLC is a residential developer, and they had a two-phase residential development out by Lake Ray Hubbard in the city of Rowlett. That's what this case is ultimately about. They hired THB Construction LLC and Travis Boney to do the initial sort of dirt work, excavation work, paving work, and sanitary sewer work on the project so that they could proceed to build houses out there. They entered into a contract with THB Construction LLC for each phase. So there's a master contract for phase 1. There's a master contract for phase 2. And this case is, from our perspective, about essentially 4 things. We have a claim for a breach of contract. We believe that THB committed numerous material breaches of the contract, which has excused the performance of Canterbury Cove any further on the contract. Ultimately, you'll hear the evidence will show Canterbury Cove terminated THB's services in June of 2020 because they were unable to get them to do the project. And there were issues with the project ongoing that were numerous. And as a result, they finally had to make the difficult business decision to switch gears, get a new contractor to complete the first phase of the project. The second claim is about a suit to quiet title. After they were terminated, THB filed a lien on the property in the amount of approximately $370,000. You'll hear evidence that that lien is false because it is dramatically overstated. And in fact, as the result of THB's misconduct and breaches of contract, they owe us money. And the third claim is, frankly, because it's a false lien, there's a particular statute under the Civil Practice and Remedies Code, which gives you the power to remove that fraudulent lien and award a penalty for the filing of a false lien. So those are the 3 essential claims. We have a Uniform Declaratory Judgment Act to the extent that any of these issues are non-ripe or need a contractual interpretation in some form or fashion. But frankly, I think the first 3 substantive claims cover the waterfront here. Here are some of the key contract provisions. The contract that you'll see, it's Exhibit 3, is the master construction contract for Phase 1. The contracts themselves between Phase 1 and Phase 2 are identical. The only difference is the bid sheets that comprise the budgets for what was happening, but the substantive terms of the contracts are all the same. And you can see here there are 7 bases for different types of material breach. And in this case, we believe there are 3 specific provisions that are applicable: 19.2, 0.4, 0.5, and 0.6. 0.4 because there were massive delay and overruns in the project that justified a termination. 0.5 here because during the course of the work, THB on numerous occasions failed to pay their vendors and suppliers, and ultimately Canterbury Cove had to actually pay them directly in order to avoid or remove liens that were filed against their project. And 0.6 is they disregarded the tree preservation plan and the ordinances of the city of Rowlett to preserve trees, and a stop work order was issued when THB cleared out a number of trees, a significant number of trees that they should not have. All of those constituted a material breach of the contract. Like most construction contracts, this one is no different. It provides a right to offset damages and requires THB to pay any excess costs that are incurred in completing the project. This is just one of the provisions in the contract that relates to this type of offset issue. 19.3, that if they're terminated and we have to complete the improvements with someone else, any excess amounts over and above what is deducted from the retainage that was being withheld have to be paid by THB to the owner. There's another provision that basically makes it very clear as well that THB has the right to withhold payments until the corrective or curative measures are actually resolved to their satisfaction. I'm sorry, Canterbury has the right to withhold. So what are the events of default? In this case, there are basically three. There are massive unexcused delays in this case. You're going to hear testimony from the client that they had an agreed schedule that they worked under that had this project supposed to be done in April of 2019. When they were terminated of June of 2020, it still was not done. You're going to hear evidence that they failed to pay their laborers and suppliers to the detriment of Canterbury Cove, who had to come out of pocket to actually pay these people themselves in order to remove liens, despite the fact that they were consistently paying promptly and completely the pay applications to THB during the course of this work. And you're going to hear evidence about them disregarding the tree preservation plan, which was a substantial violation because they removed about $78,000 worth of trees. First, with respect to the delay claim, Article 2 of this contract requires THB, the contractor, to provide a schedule of what the completion date is going to be to the construction manager and the owner. In that case, that's Bart Reeder and Canterbury Cove. Article 9 requires them to have completed the work by a completion date. And in this case, the evidence is that the only time that Canterbury Cove received a schedule from THB was in January, after they had been pressing Mike Boney and Travis Boney for a schedule like they were supposed to provide under the contract, was an email that they relied on to have them actually provide a schedule, and they did. And this is what it looked like. They said, here's the schedule, and you'll see it says there's a final out of April 15th of 2019. So Canterbury Cove proceeded under the assumption in the early part of January 2019 that this project would be completed by April 15th. And frankly, THB worked towards that. They just were not unable to get it done for whatever reason. Because there are significant delays, the phase one wasn't completed. The construction portions of phase one were not completed until sometime in the middle of 2020. There are significant delay damages. This is a contract that's in excess of $1 million. So the amount of liquidated damages agreed to by the parties is $750 a day. You'll hear expert testimony that calculates that when you give THB credit for days that were in fact unworkable because of weather, that the amount still owed to Canterbury Cove under the liquidated damages clause is in excess of $278,000. The second claim for material breach is the improper tree removal. This is an excerpt from Exhibit 89, which is where the city of Rowlett cites the ordinance violations and issues a stop work order for the removal of trees. You'll hear evidence that THB had a copy of the tree preservation plan. In fact, the contract specifically calls for them to preserve trees, and that any trees that are damaged by the contractor that were improperly removed, there's a $150 per caliper inch charge. And Exhibit 73 is a very clear example of where the trees were supposed to be removed and where they actually removed them. So if you can, this is sort of difficult to see, but all of those X's on this part of the plan are trees that should have been removed. What Canterbury Cove did was essentially remove every tree on the property on that side all the way to the border on the left side of this. So all of the area that is crosshatched and encircled with a bold, that's the city of Rowlett's marking saying these areas were removed improperly.
I have to admit, I can't tell which is which. Can you go back?
Yeah. We'll when we get to the testimony, I'll zoom in on this better. On this PowerPoint, I don't really have the ability to zoom in, but
Okay.
on the left side where it says Lake Ray Hubbard, all of that part that is sort of shaded or crosshatched there, and it's got the bold border around it, that is areas that had trees that were to be protected that were all removed. The
Okay.
trees that needed to be removed are the trees that have specific X's on them on the right side of that crosshatched shaded area. And the
Okay.
reason that there are some trees in there among the X's that should have been preserved as well. And that's why it was incumbent on THB to go out there, walk the property, and actually see which trees needed to be removed or not. And instead, what they did was just bulldoze all the trees. So, and they had a copy of this. They had talked to Mr. Reeder, the client, before actually the construction, the excavation started happening, and they didn't preserve the trees. So that's the claim for our breaches of contract claim. There's essentially three major breaches that we think justify or excuse further performance under the contract by Canterbury Cove. That further performance would be the payment of any additional monies, including the retainage that's owed. Even if it doesn't excuse performance, our contention is it certainly gives us a right to offset whatever their claim is under the retainage that they can approve or establish they actually are owed. The second part of this case is about the lien removal. They filed a false lien against Canterbury Cove in June or July of 2020, within a month or so after being terminated. And Canterbury contends that lien is false for four reasons. One is the $370,000 is comprised of essentially several categories of charges. One of them is a pay application number 11 for their final draw, which has some specific charges in it that we'll discuss that should not have been charged. As a result, that pay application is overstated. They've overstated their claim for the phase one retainage because if you make the deductions that should have been made on their last draw application, that changes the 10% retention and reduces it. And so that number is overstated. They re-invoiced tree charges against Canterbury Cove. And so the way Canterbury Cove, and you'll hear evidence about this, the way they dealt with the improper tree removal was to pay the city of Rowlett the fine that they were owed so they could get the stop work order lifted, which was approximately $45,000. And they withheld that money from the pay application number 10, which was the final one that they paid before they ultimately terminated THB. THB disagreed with that, even though there's not a basis for them to disagree with it because the contract clearly allows for the withholding of funds or even expressly a chargeback to THB for amounts that they have to be, that are done in violation of the tree preservation. But they went ahead and re-invoiced that $45,000 that was deducted and we think agreed to back with pay application 10 on their final pay application that was submitted with the false lien. So that overstates the lien amount by at least $45,000. And then the final category of reason this is false is that there was premature claims for phase two payments. Phase two has not technically or formally commenced, but THB overpurchased the supply of pipe and for the sewer. In fact, they purchased all of the sewer pipe for phase one and phase two at the beginning of this project instead of sequencing it. And they asked if they could go ahead and install or lay the sewer pipe so that they could, because they had this inventory, and Canterbury Cove agreed. So they put in pipe in phase two, Canterbury paid for some of it during the course of that work. Now they're asking for the rest of it plus the balance of the retention. The problem is it's premature because a final payment under the express terms of the contract is not due until there is final approval of the phase by the city and by the owner. That has not happened yet. And the reason that's significant is because one of the things that has to happen in order for that approvals to occur is there has to be testing of those sewer pipes to make sure that they are sound and free of defect. And until that testing is done, Canterbury doesn't know if they need to withhold or deduct from the amount of money that was paid for that work from the final amount owed. And so it's just simply premature. It should never have been on the lien because that amount isn't due yet. It's not right for payment. So those are the four examples. for reasons why the lien is falsely stated. In addition, Canterbury Cove has claims for damages for mitigation expenses to correct the issues that had to be corrected and to complete the project after they terminated the contractor. This is a summary from the of the charges that are in evidence now for work that was done after the termination of the contract by THB by Canterbury when they hired a new contractor to come in and complete the job. This is work that either should not have had to be done, should not have had to been paid for by another contractor had THB done the job and completed its contract because there was already a contract in place and this was already accounted for, or it is work that was corrective, in which case THB should have done the work as part of their job. And you can see the total there is $83,000 roughly. There's going to be future mitigation costs as well. There was excess paving put in beyond phase one that's likely going to have to be demolished and resurfaced and relayed when they actually start the phase two project. There was resurveying work for phase two that needed to be done because the elevations were not done correctly by THB. There's potential sanitary sewer work in phase two for testing, and we've put in an estimate for potential dealing with the corrective measures that may need to go in for the work they laid back when they did phase one work. And then the cut and fill for the phase two section as well is going to have to be redone because of the survey changes. And that amount is roughly $28,000. And this is the line by line of why the pay application number 11 is overstated. I won't go through it here in detail. We'll talk about that during the direct, but it's roughly overstated by about $78,000. I believe the total pay application that was submitted with the lien is in excess of $80,000. And so you can see of the 370,000, roughly 80 something thousand is related to pay application 11. And of that amount, roughly 78,000 is overstated. And this is the math on why the retention amount is overstated. And so this is essentially what we believe the evidence will show with respect to what is owed to Canterbury Cove. If the court finds, and we think the court should find, that there is a material breach that excuses payment, then we don't owe THB any additional monies. But they do owe us money for these contractual damages related to the material breach and the actions that they took as a result of that termination. And it's in excess of $475,000. It includes a significant delay damage claim. It includes a significant attorney's fee claim, and it includes a false lien penalty of $10,000, which is the minimum one under the Civil Practice and Remedies Code, because they never should have filed this lien. Given the significant issues with the claim. This is an alternative claim if the court believes that there wasn't a material breach and that all of the amount on the false lien is provided, it is susceptible to recovery. Then even then, there are significant offsets that make the lien still false because these should have been taken into account and that never should have been filed, but the offset still means that Canterbury Cove is owed $176,000. So we think the evidence is going to show that Canterbury had significant material breaches and excuses our performance, and they owe us almost $500,000. But the best day for THB is there wasn't a material breach. We have a claim for some sort of the value of our services less what we owe you. And that means their claim, the damages are reduced to $176,000. And with that, I will close. Thank you. Let me stop my slide.
Okay, does the defendant have an opening statement?
Yes, Your Honor. This will be brief. And with the court's permission, if we can split this up, there's I think a significant issue that Ms. Hayes will address, but in total will be 10 minutes at most if the court will permit. Just a split opening where Ms. Hayes speaks to one of the issues, but let me just first open up.
No problem.
Okay, thank you, Your Honor. That we believe the evidence will show that there was performance by THB. The work was near complete at the time that it was then asked to leave or terminate. And all that was left as described by Canterbury Cove is there was a few punch list items. As you saw in the numbers, the most significant amount, over $278,000 for liquidated damages. Ms. Hayes will address that issue where it's our position. The contract language does not provide for liquidated damages as there was no completion date in this contract. That's common with contracts. There's not a completion date, and she'll go through that. But again, what we will present is the lien affidavit amounts were substantially complete. The largest component is retainage, and again, that's just money held back on pay apps that in fact were paid. So I don't think there's a dispute about the $184,000 retainage. I think what Canterbury is saying is, well, we have offsets to that. And again, that was almost half of the lien affidavit amounts. We'll go through the other amounts that we say were not paid. And as you've heard, there was some work on phase 2, and by agreement, some work was done. And there is a portion of that work that has not been paid on it. So we think our number is substantially correct. And I'll now let Ms. Hayes discuss the issue.
What is your number?
Our number is $345,114.42. That number is in the lien affidavit, less we have taken out a claim for payment of a maintenance bond of $21,270.78. So in exhibit, it's actually exhibit 1 is the lien affidavit, and on the 4th page of that is the calculation of the amounts less the maintenance bond, and there's backup documents. So that's our number, has always been our number. But again, just in brevity, the majority of their offset number is delay damages. And I'll let Ms. Hayes address the contract language and why we contend there is no contractual delay damages in this case because there's no completion date.
Ms. Hayes, are you connected to audio?
No, Your Honor, we are actually in in the same room, so I'm going to actually just swap places with Mr. Hayes, if that's okay. All right. Yes, Your Honor, as Mr. Hayes was saying, there is no completion date as per the terms of this contract governing phase 1 of the construction. In order for there to be a completion date, it must be in a project supplement. Project supplement is a defined term in this contract. It is defined on page 4 of the contract, which is exhibit 3. States that it is, and I'm not quoting verbatim here, but it says that owner specifically engages contractor to perform work on a particular project. I believe that the plaintiff will assert that the email exchange between plaintiff and defendant, where defendant states that the final date is in April of 2019, that this constitutes the completion date. This, however, cannot be the completion date as this email is not a project supplement as defined by the terms of the contract. There was not an actual completion date, therefore, Article 9 was never triggered. Because Article 9 was never triggered, there's no liquidated damages that could be given to plaintiff. Thank you, Your Honor.
All right, anything else?
No, Your Honor.
Okay, Go ahead and call your first witness.
Thank you, Your Honor. Your Honor, the plaintiff would call Bart Reeder.
Mr. Reeder, please raise your right hand. Do you swear or affirm the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
You may proceed.
Thank you. Mr. Reeder, can you go ahead and tell Judge Hoffman your full name, please?
Full name is Barton Michael Reeder.
All right. And what do you do for a living?
I am licensed as an attorney initially, and I am currently, and before that, even before licensing as attorney, I've been in the home building and real estate development business.
All right. When did you graduate law school?
2001,
And what school?
Texas Tech.
Go Raiders. What did you do after law school? Did you do private practice?
Yes, I was in private practice for nearly 5 years, about 4.5, 5 years, and then was with a firm that did both litigation and real estate transactional work, and wanted to move more towards construction and development.
All right. And how long did you do the private practice?
4.5 to 5 years.
All right.
From
And,
roughly 2002 to 2000, end of 06, beginning of 07.
all right. And how did you transition out of private practice? Where'd you go into?
I actually entered a partnership with my father, Ted Reeder, and did another land development, and where we bought raw land in far north Dallas, developed that, and built 42 homes on that from about 2007, and then hit the downturn of 2008, 2009. So we didn't finish that, completed out until about 2013, 14.
All right. And have you been doing real estate development ever since?
Yes.
How many real estate projects would you estimate you've done in the time you've been in that line of work?
Land development specifically, just 2, but as far as other, in terms of taking raw land and developing it into multiple lots, just 2, but at the same time, we were also doing construction projects where we bought existing homes, tore them down, replatted, rezoned in the city of Dallas, and that was another 3 projects like that since 2014, 2015, since that time.
From a size of the project, do you have an estimate of sort of dollar value size of these projects?
Well, relative to Canterbury Cove, or just generally, or each of them?
Just generally, and then I'll ask you to compare it to Canterbury.
As far as the Davenport Meadows was a roughly $4 million project. The smaller projects in between before Canterbury Cove were 1.5 to 2 million, 2.5 million. And then Canterbury Cove was altogether, both phases, about 5.5 million.
All right. And given the amount of time and the number of projects you've done in real estate development, do you consider yourself experienced at this point in real estate development?
Yes.
All right. And why do you consider yourself experienced?
Well, I've handled, being a smaller business, entrepreneur, smaller operation, I've handled most of the different tasks directly, from the financing, from locating the property to financing the purchase, negotiating with the sellers, negotiating with lenders, investors, to working with contractors and engineers to get plans designed, engineering work designed, figuring out what could be done with the city, negotiating with the city about replatting, rezoning, attending city P&Z meetings and city council meetings, and then up through actual construction and getting the final completion. I feel like I've handled most of those different tasks myself, and I mean, I enjoy that. That's something I like doing. So it's not that I feel put upon at all. It's what I enjoy doing, but I do feel I've gotten a good bit of experience in those different areas.
Have you had any specialized training or education related to real estate development beyond the law degree?
No. Yeah, some of my law classes involve real estate, but other than that, no, not specific educational.
All right. Despite the lack of specific, postgraduate educational work with real estate development, do you believe you have an understanding of standard construction industry practices and customs in the Dallas-Fort Worth Metroplex area?
Yes, I've only worked in Dallas-Fort Worth area, so I wouldn't say that about other parts of the country, but about Dallas-Fort Worth, yes.
All right. And do you believe you also have a specialized knowledge based on your experience of contracts for construction projects in the Dallas-Fort Worth area?
Yes.
Do you have an idea of how many contracts you've either negotiated or entered into over the course of your construction work history?
As far as construction, specifically construction contracts, or all kinds of contracts relating to real estate?
Well, let's break down first with respect to construction projects.
With construction projects, obviously, written construction projects, obviously not as many as oral. As I said, I work with the subcontractors, contractors directly, so we have enough. I've had many just oral agreements of what they're going to do and what they'd be paid, and obviously that's more specific, more detailed, more narrower than Canterbury Cove project. But in terms of numbers of contracts, written contracts, like you're talking about, probably 10 to 20 in the last 5 to 7, 8 years.
Okay. All right. And we're here today because of a dispute that arose out of one of your projects with THB Construction, right?
Mm-hmm. Yes.
All right. And what is can you describe for the court what the Canterbury Cove project is?
Yes, Canterbury Cove is a tract totaling 21.8 acres that we located several years ago and decided to purchase after approximately a year's worth of due diligence, investigation, and research into what the city would allow, what could be done, roughly how much it would cost, and ultimately, as I said, purchased it and had already determined at that time we could build a new residential community that would have 109 lots altogether, have required rezoning and replatting with the city of Rowlett, of course, and then of course substantial engineering work to be done to put in all the infrastructure, because previously it had only been farmland, was agricultural land prior, so it had obviously no infrastructure in terms of water, sewer, stormwater, streets, all those things that go into a neighborhood.
Sure. And I'm going to share my screen, show you what is marked as Exhibit 6. Can you see that?
Yes.
Okay. And let me rotate it here. And is this a site plan for the Canterbury Cove project you just described?
Yes.
All right. And you see here there's a phase 1 and a phase 2. Can you describe generally for the court what the phase 1 and phase 2 means?
Right. We determined roughly, and I want to say early 2018 or end of 2017, that the total cost of the project was going to be more than we had the wherewithal to handle in one phase, and figured out, and just looking at the overall plan and the engineering work we had done, that we were it split itself into 2 phases fairly simply, because the sanitary sewer and storm lines there's basically one on the north end and one on the south end, and splitting it into 2 phases was relatively straightforward in that sense. It didn't require a lot of re-engineering, redesign. And so we figured out, okay, we can split this into 2 phases, and it would cost roughly $3.25 million to do phase 1 and roughly about $2.25 million to do phase 2. And that was within our financial reach to do that project. And so the phase 1, what you're seeing here, the southern half is got in the bottom right corner is 4 blocks of 6-unit townhouse buildings, so a total of 24 lots in the bottom right. And then the remaining lots in the entire project are all single-family detached houses. And so on the upper, setting aside the 24 in the bottom right corner, that's southeast corner, there are, as I said, there's 61 total. So in phase 1, leaving 37 of the single-family detached in phase 1. And then on phase 2 there are 48 lots.
Okay. And Canterbury Cove LLC is responsible for the project, right?
Yes.
Does Canterbury Cove LLC own the property?
Yes, Canterbury Cove LLC owns the entire tract.
All right.
Phase
And
one and phase two.
I believe the special warranty deed showing that, I'm not going to show the court because it's in evidence. The special warranty deed establishing, apologize, Your Honor, is exhibit 7, Your Honor, establishing the ownership by Canterbury Cove. What's your position with Canterbury Cove LLC, Mr. Reeder?
I am the managing member of that LLC and president, operator, chief bottle washer.
Okay. Are there, we know that there's a lien filed against Canterbury Cove by THB in this case. Does Canterbury Cove have a lender for this project?
Yes, the lender that did the original, there's one lender, the original lender was Legacy Texas Bank, which was purchased by Prosperity Bank in middle of 2019, I believe, or early 2019. So at that point, it became Prosperity Bank. So currently, the one and only lien holder or the loan company is Prosperity Bank.
Okay. Do they have a security interest in the property to collateralize their loan?
Yes, the entire property is collateralized.
What are your responsibilities with Canterbury Cove LLC?
As I said, I do most everything as far as I have a construction trailer on site. I've been working on this from the beginning. I was the one that first spotted the land and in 2016, I believe. And since then, been working with engineers and the seller and brokers, the city, contractors, investors. Those are all people I've been back and forth with and over the years to try to get the job done and make sure there's money to pay for all the bills, of course. I mean, having had experience in the past with development, I've learned I want to be on site to supervise what's going on and know what's being done or what's not being done, and be able to, again, with my experience, I'm comfortable being there. I'm comfortable doing that. It's what I enjoy, is being on site and looking at seeing what's being done, and then addressing issues, addressing problems when they arise, which they always do. So
Okay.
I was there most of the days.
All right. And you, in that role, you entered into a contract with THB to do the initial excavation and sewer and paving work, right?
Yeah, the original contract had them doing both phase one and phase two. And when we split it into two phases, phase one still included grading and clearing the entire property, both the land that was being phase one and phase two.
All right. I'm going to share my screen and show you what's marked as Plaintiffs Exhibit 3, which is the master contract for phase one. Is this a contract that you ultimately entered with THB?
Yes.
And who drafted this contract?
This was a contract drafted entirely by THB, presented to me for my review.
All right. Did you make any revisions or additions to the contract?
No, I don't believe we did, other than possibly changing from the first draft. We may have changed the budget at the end, the exhibit that had the budget, the cost breakdown, 3 or 4 pages. Other than that, no, I did not make any changes. I was pleasantly surprised that the terms were, I thought, very balanced between owner and contractor. So no, I did not make any changes.
All right. We're going to talk about some of the specific provisions here in the contract. The first provision I want to focus on is the definition of contract documents.
Yes.
You've seen this before, correct?
Yes.
And contract documents includes approximately 5 things that are itemized there. One of them is the master contract. And then one of them is Romanet 2 says the quote project supplement covering the work to be performed. Do you know what the project supplement is in this case?
The only supplement that we made to this contract, other than the change orders mentioned in 5 below, was the email from Mike Boney about the schedule.
Okay. Did Canterbury Cove ever receive a quote project supplement from THB Construction LLC?
Never received a document titled project supplement. No.
Did you ever receive anything that THB Construction LLC called the project supplement?
No.
All right. And if we go down further in the definitions, project supplement, even though it's capitalized up there in that provision, I'll go back so that the judge can see it. It's not a defined term in this contract, is it?
No, sir. It's not.
And so you can see here as part of the contract documents, it would include the project supplement, which is capitalized, but there's not a provision defining what project supplement is, right?
Correct.
All right. Now, Article 2 is basically what they're being paid to do, right? To do construction.
Right. The work that THB was being hired to do. Yes.
And it's your understanding that they were to complete the work in, as it says here, first class and good workmanlike manner, and in strict accordance with the requirements of the contract documents, correct?
That's correct.
Do you believe that THB Construction LLC actually complied with the provision of strict accordance with the contract documents?
In some respects, yes, but ultimately, no.
All right.
Overall, no.
Now, paragraph 2.2 here specifically says that the contractor shall prepare and submit, after instructions from the owner, to commence an estimated progress schedule for constructing the improvements to be approved by the manager and owner. Do you see that?
Yes, sir. I see that.
All right. Did THB Construction LLC provide at the time of execution of this contract an estimated progress schedule?
No, not at that time.
Did you give THB Construction LLC instructions to commence work?
Yes.
And did THB Construction LLC commence work shortly after the signing of this contract?
Yes, within a month.
Okay. And just so we'll come back to this page, sorry for the quick skip down here, but this contract was signed, that's your signature, right?
Yes.
It was signed on the end of November 2018
Correct.
by you, but it was signed by THB Construction at the beginning of November, correct?
Right. That's right.
Okay. And so anytime between those periods of time, November 7th, 2018, when THB signed the contract, or November 28th, when you signed the contract, did you ever receive an estimated progress schedule or completion date from THB Construction?
No, I did not.
Did you ever receive a project supplement from THB Construction?
No.
Was it your understanding that THB Construction LLC was the party responsible for providing that information to the owner, Canterbury?
Yes, it only makes sense. Obviously I can't dictate when they will complete their work. I have to rely on them to say when they will complete their work.
Oh my goodness, computer's going crazy. Sorry. Go back up here to paragraph 2. Now, did you ask THB Construction LLC to provide a estimated schedule for completion after you entered into this contract?
Yes.
When did you first start asking for a schedule?
I believe it was around middle of December of 2018, roughly a month after they had gotten in and started doing the grading excavation work, and had started some of the other underground work as well.
Okay, and why did you wait a couple of weeks or a month or so after the initial commencement of the work to ask for the estimated schedule they should have provided?
Well, at the time we signed the contract, it was it was a period of a lot of rain. I don't know if you remember it. I remember it fairly well, that the land was all the land around was very wet. That just couldn't get any work done. And I remember specifically meeting Mike Boney and his grading crew on site before Thanksgiving of 2018, and all agreeing it was raining at the time, lightly raining, and it was just muddy, so muddy that you couldn't even get the heavy equipment. Would just be, I think Mike's words, would just be playing around in the mud. which I had to agree with. It was that wet, and being farmland, this was slow to drain property. This wasn't fast sloped ground, so it kind of held water, and it had always held water. So it was my expectation in middle of November that they wouldn't start until at least after Thanksgiving and probably first part of December. So based on my experience with construction, of course, I know that as a contractor, it's awfully hard to project when you're going to be complete when you don't even know exactly when you can start. Given the wet conditions, who knew if it may well have continued raining for another 3 weeks, for all any of us knew, in which case, if I had tried to pin them down on a date when it was in middle of November saying, well, I know it's raining right now, but it's, assuming it stops raining tomorrow, then whatever date they gave me of that would be meaningless, because if it didn't stop raining, that was just thrown out the window. It didn't have any significance to me. So from my experience, if it was me, I would want to be able to get into the project and see, once I got started and had made some progress on it, would be able to have a better grasp of saying, okay, this is how long this is going to take. This next step will take this long. We should be able to get finished by this date later on, once they had gotten started.
Okay.
So that was my intention, to give them that chance to do that before trying to pin them down on a completion date.
Okay. And so in mid-December is when you started asking for a schedule?
That's right. Yes.
And did you get a schedule right away?
No, it was over the Christmas and New Year's, and we had a meeting with the city, I believe, and in person, and I was talking to Travis Boney about it then, and as I recall, that was a Monday, and we had lunch the next day near the site, and was asking about it then. That was going into January at that point.
Okay. And we'll talk about that a little bit more. I want to continue talking about the specific terms in the contract real quick, but ultimately you did get a schedule from PHB Construction.
Yes.
All right. The next thing I want to talk about here is with respect to the contract provisions for payment. You understood, as is typical in construction contracts, that you were to make payments as the construction work progressed, correct?
That's right. Yes.
So paragraph 3.2 talks about how that process would work. That's your understanding?
Correct. Yes.
And I'm not going to read the whole provision for the court. It's there on the screen, and this is in Exhibit 3. But basically, the way it would work, correct me if I'm wrong, is simply they would do work. They would bill you at the 25th of the month for work done in that previous period. They would withhold the 10% agreed retainage amount, and you would pay that draw within 20 days.
That's right. Yes.
And in addition to that, they would provide a conditional waiver and release that the work that they had done, they had paid their suppliers and laborers, so that there would be no mechanics or materialmen's liens placed on the property, right?
Well, it's conditional that they would use the money. Yes, that they would pay. They had paid them or would pay them. Yes.
Correct. Okay. Now, paragraph 3.3 is a provision that provides the owner the right to withhold. Is that correct?
Yes.
And what was your understanding of Canterbury Co's right to withhold payment from THB Construction LLC?
That if THB didn't complete the work, or the work was defective such that we had to get somebody to fix it, if THB didn't come back and fix it, or there was, I guess, a dispute over whether the work was satisfactory or adequate, that we would be able to withhold payment if we had to go get someone else to fix the work. And then what became more pertinent to me was the second item there, that the lien claims, if the supplier or subcontractor was filing liens because they hadn't been paid by THB, that we would be able to withhold payment to make sure those subcontractors and or suppliers had their claims paid, or at least resolved, because they would ultimately be filing a lien. The lien would be filed against Canterbury Co's property.
Okay. So that you talked about an example there. Were there examples of where liens were filed against the property because THB Construction LLC did not pay them during the course of the work?
Yes, I can think of two off the top of my head, but I received many certified letters from suppliers at my home address because that was one of the addresses that they had
Okay.
For threatened liens as well.
Okay, there's another provision here. The first Romanet is for defective work not remedied. So that would be for things you could withhold payment if, for instance, you had to repair concrete work.
That's right. Yes.
All right. And then there's also a provision here, Romanet 4, for damage caused by the contractor or subcontractor. That would be withholding payment if they cause some sort of damage to the property itself, right?
Correct. Yes.
So, for example, improper tree removal that caused the city of Rowlett to fine the construction manager and owner would be a damage that you believe could be withheld.
Yes.
All right. And then you could also withhold if there was the failure to comply with material terms of the contract, right?
Yes.
Okay. Do you believe that in refusing to pay the final amounts that are ultimately claimed in the lien, that paragraph 3.3 granted you the contractual right to lawfully withhold payment?
That was my understanding from it. Yes.
All right. And let's look at the final payment provision. Paragraph 3.4 specifically says that final payment is due when, one, the contractor's work has been fully performed and accepted by both the governing public authority and the engineer, and two, contractor has furnished to owner a conditional waiver and release, on final payment. Excuse me. Had those two conditions been satisfied at the time of termination by THB Construction in June of 2020?
No, neither one.
All right. Had those two conditions been satisfied at the time THB Construction filed its lien against the property for approximately $370,000?
No, neither one had been.
So it's your understanding that final payment to THB Construction was not yet due, but they filed a lien anyway saying you had to pay us?
Yes.
Okay. I want to show the court some examples of the pay application. You don't care about my email. All right, can you see Exhibit 8 there, Miss? Oh, you can't because I
No,
haven't
I
shared
cannot.
it. I haven't shared it. Can I click the share button? Can you see
Yes.
that, Mr. Reader?
Yes, I can.
Okay, and this is what the pay application form that was used by the parties in this relationship looked like. Is that right?
Yes, this is a form provided by THB. Correct.
Okay, and this is the first draw, and it's dated, as you can see there, it's dated November 25th, 2018.
Right. Yes.
And the way, I just want to walk through this so the judge understands how this sort of flows. I think it's self-evident, but just make sure the record's clear and he understands. The way they would submit a draw is they would they tell you what the total contract price is, and I'll zoom in. Hopefully that will help see everything. Is that better, Your Honor? They tell you what the original contract price is. So the 1.6 million roughly for the original contract, that was the agreed upon budget that was attached to the master contract when you entered the contract, correct?
That's right. Yes.
So if on November 25th, they magically were able to complete all of the work and the project was completely done, you would owe them 1.668 million roughly.
Yes.
All right. But obviously this took longer and they did it in draws. And so the way this works is they tell you what the original contract price is, and this is the first draw. So there are no change orders that adjust that price, right?
Correct. That's right.
And then they tell you in line 4, what is the total amount completed to date of the pay application, right?
Yes.
And in this case, it's approximately $209,338.75.
That's right. Yes.
And then the contractual retainer was 10%, right?
Correct. Yes.
And so they withheld 10% from what they actually requested to be paid at the time of the submitting of this invoice.
That's right.
And that leaves a total due of, in this case, $188,404.88, right?
Yes.
All right. And did you make that amount? Did you pay that amount timely?
Yes. We submitted it to our bank, made the draw. The bank did their inspection and ultimately released the funds to us, and we paid THB.
Okay, and I'm going to show you this is in this particular example, the pay application has the detail attached. And for your honor, for the courts, so you know, some of the exhibits they're separate. So as we'll go through this, you'll see the pay application form is a separate exhibit from the pay application detail, but I'll try to make that clear. This particular exhibit happens to be all together, but the second and third page of this and fourth page of the third page, sorry, second and third page of this are the detail sheets, correct?
That's right. Yes.
And the way this typically worked in your relationship is there's a column that says quantity this estimate, which is in this area here, correct?
Correct. That's right.
And so that's what makes up essentially the amounts for this particular pay period that they're asking to be paid.
Right. Because it's the first draw, there wasn't anything on the previous quantities to the left.
Okay. And as we'll see examples as we go, that as you get to the next draw, the previous amount column gets filled in, right?
That's right.
And then they have a completion percentage that's an estimate of how much work they've done on that particular job on this project.
That's right. Yes.
So for example, after draw one, what is the percentage completion of erosion control?
They've got of the total. Well, they don't have the category of erosion controls 3 items and 100%, 0%, 100%.
Okay, so this would tell you essentially, if you look just at the detail sheet, that as of November 25th, for instance, they had completed putting up the silt fences.
That's right. Yes.
Okay.
And they put the construction, the top line, the construction entrance, the rock down on the ground. That was done. 100%. Right.
Okay. And then this totals at the end, it totals what the total amount owed is, and then takes out the retainage, and then gives you the total subdivision less the retainage, right?
That's right. Yes.
Okay. And then the final page of this packet is a conditional waiver and release, right?
Yes.
And this is required to be provided at the time of an application for payment under the contract.
Yes.
And as far as you know, you got one of these for every one of the pay applications.
Yes.
Okay.
Executed by THB.
Yeah, it's executed by THB. In this case, it's executed by Mr. Boney, Travis Boney.
Correct. Yes.
All right. Let's look at.
And that form had to be submitted to our bank as part of the draw as well.
All right. I'm going to show you what's marked as pay application number 2. This is, I'm sorry, which marked as exhibit 12, which is pay application number 2. And this is same general process, correct?
No, I don't see it. It's not being shared.
Oh, yeah, I got to share it. Thank you.
Okay. Yes, this is the next month. This looks like the second one, right?
Yeah, right. So this is number 2. This is exhibit 12 for the court. In this one, you can see here that the total completed to date has increased beyond the 209,000 because there's some additional work that's been done, right?
Right.
Okay. And then there's the retainage amount is being withheld. And then it shows that there's a line here that wasn't on the previous one filled in because that was the first one. Here it says less previous applications. What was your understanding of what the line 7 represents?
That represented the money that THB had received from Canterbury Cove for all the prior applications, which was just one at this stage, one prior application, but tells me they've been paid or they've accepted payment of it, is how I read that.
So the way this works is they tell you what the total amount of work done is, which is cumulative for the first draw to the second draw. And then they deduct out the payments that they've received on those previous draws, which leaves a balance owed.
Right. Yeah. 7 is a cumulative of all the prior. Line 6 is a cumulative of the work done, and 7 is the cumulative of the payments, leaving the balance, the current balance due.
Okay, so for example, in this case, between draw number 1, which was sent to you on November 25th, 2018, and draw number 2, which was dated December 25th, 2018, based on this document, you can tell they've already been paid within that 30-day period.
Correct.
And in this particular instance, they're owed another $114,000.
Correct.
Did you pay them that amount timely?
Yes.
Do you know, was there ever an instance where you were invoiced for a draw or on a pay application, but the full amount or a significant amount from the previous pay application was still due and outstanding?
No.
As far as your understanding is, every time that you were asked to pay THB Construction during the course of this work, you paid them within the contractual terms or close to it?
Yes. I never heard complaint from THB until those lien was being filed, and we were in June of 2020, and then I started hearing that we had been late with prior payments, which was a mystery to me.
All right, and I'm going to show you now, skip forward and show you Exhibit 39. And Exhibit 39 is pay application number 10, correct? Oops.
Yes. Right.
So this is the last pay application that Canterbury Cove actually paid money to THB Construction on, correct?
That's right.
And it's dated April 25th, 2020.
Yes.
And you can see here that the contract price here is now about 1.7 million. And why is that?
Because we had 3 executed change orders in the course of 2019. I want to say March and April, and maybe again in September. We had 3 change orders for change of the work, change of the scope of the work, that added, as you can see on line 2, a total of almost 126,000 to the job. So that raised the total contract price an equivalent amount. And then line 4, where you've got the cursor, is how much they were asserting that they had completed at that point of that grand total.
Okay. And then the retainage amount of the grand total is approximately 176,000.
That's right. Yes.
All right. And now if we look down here at line 6, it says 1.584 million roughly in total of completed, less the retainage.
Right. Yes.
So that is telling you that they're almost done with the contract, but they're not quite done, basically, right?
Right. Yeah. You can look at the line 3 and line 4, and they're roughly 34,000 from being complete. Right.
Yeah.
Yes, sir.
And then line 7 is the last previous application. So that's the amount as of April 25th, 2020, that THB is telling you that they've already been paid.
Correct. Yes.
And then the final line there is the amount due that they're claiming is owed for application number 10.
That's right. Yes.
All right. And did you pay application 10 promptly and timely?
Yes. Some of those payments went to other contractors or suppliers because they were joint check agreements at that stage, but they were joint checks to THB and those suppliers. But yes, that 216 was paid.
All right. Was the total 216 paid, or did you withhold amounts from this pay application?
Yes, I was about to say we did withhold 45,000 from that for the trees after having that discussion. Yeah, that was withheld at that point because we had that discussion with Travis and their attorney at the time on site, and reached that conclusion that that's how we would handle it.
Okay, and so the balance of approximately $171,120.96 after withholding the tree amount, you believe you paid to THB?
Yes.
Have you ever received any complaints until this litigation about delays in payment, or that they were not paid all that they were owed during the course of their work?
No. We had disputes along the way to some extent about the claim amount they were claiming, And I would say, well, you haven't got this work done yet, and wanted them to take off various items. They went back and revised their draw request, resubmitted it. Ultimately, we paid it, that revised one, and that's what is being shown here on, line 7 shows that we ultimately paid those amounts.
All right. Now, ultimately, you decided to part ways with THB.
Correct.
When was the first time that you had you would consider a significant conversation with them about potentially terminating the relationship?
Thinking back around the end of 2019, before I believe when we paid either draw request 8 or 9, pay application 8 or 9, was right before Christmas of 2019, and thereafter, immediately, very shortly thereafter, I believe it's 26th, is when we got the stop work order notice from the city of Rowlett. And at that point, we're talking with them, well, what are we going to do about this? How are we going to get this handled? We need you to get back on the job so you can get to work. And to my surprise, THB was not terribly concerned about getting back on the job in last week of December, first week of January. And that was concerning to me at that point, because I said, obviously you're not done here yet. We've got work left to do. Why aren't you getting it done, or why aren't you pushing to get this done and figure out what do we need to do to satisfy the city so we can get back to work? So it was early June or early January that we were having concerns that they were not going to finish, or if they did finish, it would be at their leisure. Essentially that we felt like we were fill-in work for them at that point. They would get around to finishing our work when they got around to it. They had other jobs they wanted to work on instead. By March of 2020, I was again at the construction trailer on site and not seeing people working there, except at the concrete batch plant where they were loading up concrete into their THB trucks, using material delivered to our site. I say material, the crushed rock, the cement, water, the sand that goes into concrete, mixing that, loading it up into their THB trucks and trucking it to other jobs. Had a discussion at that point saying, hey, we've got to get our job done. You're obviously working at other sites and not this one. That was around the March 10th or 11th, and had a sit-down conversation with Mike Boney the second week of March. And I think that answers your question when it started. That was the first serious, full-on discussion about their lack of work at the site. Okay. It was early March 2020.
Did you send them a written warning about their work and the demand that your work would come first?
Yes, I wrote a letter and sent it to Travis and Mike, I believe, by email and certainly by regular mail. I don't recall if it was certified or not. I think it may have been certified mail, trying to comply with the terms of the contract. Okay, I'm going to show you Plaintiffs Exhibit 91. This is a letter dated March 11th, 2020 to THB Construction LLC. Is this the letter that you just described? Yes. That was the first letter, formal letter.
Okay, and here you put in all bold on the first page that THB must have a substantial crew of workers on the site by tomorrow and working continuously to complete the work listed below it and any other necessary work to complete phase 1 until this job is complete. Did you consider that time was of the essence in this case? Yes, it was. Yes, very timely. Time was very much of the essence in the sense that we were accruing interest and various other fees every day that work wasn't getting done, and of course that's continued till today, for that matter. Yes. Yeah, and in fact, the sentence right before that says the delays are costing Canterbury Cove over $19,000 a month. You see that? All right, and what does that $19,000 a month roughly represent? That is mostly about 2/3 of that is the interest that we were paying to Prosperity Bank, roughly $12,000 a month. On that, essentially the numbers you had there earlier, what they had drawn from the earlier pay applications, as well as the borrowed money for the land
And then, like I said, 12,000 was monthly interest payments. Roughly 3,000 was taxes and insurance, annual taxes and insurance for the property. And then also we had investor fees to investor, not fees, but the ultimate payment to investors was accruing similar to a bank loan. And then just ongoing costs, overhead costs, including construction trailer, adds up to the rest. There's not, that includes no salary or payment to me or anybody else for Canterbury Cove. That was strictly costs we were paying out of pocket on a daily, on a monthly or annual basis.
So there was a legitimate, significant monthly cost associated with the delay work,
Yes.
delay in work by THB.
Yes.
All right. Now, I'm going to show you Exhibit 94, which is a terrible copy, but it's the only one I think the parties have, of a second letter you sent approximately 2 weeks later. Do you know what this letter is?
Yes, that would be, I don't see it being shared right now.
Oh,
but,
yeah, gosh. Do that. Thank
I'm
you.
familiar with it. That was after we had met with Mike Boney. I believe, oh my, that is a bad copy of that letter. Okay.
It can still, you just got to focus. That's okay. Is this the termination, the initial termination letter?
Yes.
All right. And you sent this on March 23rd.
Right. We had a meeting with Mike Boney in person to discuss what was in the earlier March 11th letter, and then they had continued. They had done some. I believe they'd started doing some work at this point, but hadn't really done much.
Okay. In this letter, you referenced specifically their commitment or their estimated final out date of April 15th, 2019. Correct?
Correct.
Did you ever get a written response or a response back from THB Construction disputing that was the final out date?
No, never did.
And you declared them in default under several different articles of the contract, articles 2.1 and 2.2 and 9.1, correct?
Correct, yes.
And 2.1 is the strict accordance, good and workmanlike condition clause in the contract, right?
Yes.
And 2.2 is the estimated time of completion part of the contract, along with 9.1, the delay provision, right?
Yes.
You also referenced in this letter the failure to pay suppliers. That was a concern for the second half, basically, of the work that THB Construction was doing, right?
That's right. Yes.
Okay, and we'll go through some of those examples in just a second. Ultimately, did you terminate the relationship immediately after March 23rd, or did you have further discussions with THB Construction?
Very shortly after sending this letter, I believe it was a Monday, I sent this letter, emailed it to him as well as by certified mail I think noted at the top. But within 2 hours or so, I heard from THB's attorney at the time, Bob Kemp, who called me up and said, "Oh no, we don't want to terminate this. You know, if you let THB get back on site, they're ready to get back to work and want to get the job done and are committed to finishing it." And basically insisting that we let them, if we'd let them essentially take back the termination so they can go back to work. And in his view, I had to, let them come back to work and not be terminated anymore. Then they would be back on site the next day. I take it may not have been the very next day. Like I said, it was a Monday, and I talked to him, I want to say 4:30 in the afternoon that day. I think we were talking about getting back to work first thing Wednesday morning, a day and a half later. So, and so at that point, I said, well, if they're going to be out there on Wednesday morning, then they can get to work.
So you sent this letter attempting to terminate them, but you essentially gave them one more chance.
Yes.
And did they get back to work?
They did. They finally started back to work. We seemed to have an agreement on what needed to be done. One of the comments in our earlier letter and meeting with Mike Boney was that we need to have a person on site that was in charge, a superintendent. As I recall, they didn't have anybody there Tuesday. Again, Don Peak had been there previously. He was there Tuesday, and I remember taking issue when I saw him there, that I said we need somebody that's actually going to be here and doing the work, as opposed to what Don Peak had been doing. Wednesday, then I believe Travis was there and was ready to go to work and had crews there and people ready to go to work Wednesday morning, 2 days after this letter.
Okay, but did they continue the work, even though they showed up? Did they continue the work diligently to completion?
For about 2 weeks, they did work diligently. I was pleasantly surprised that after I finally thought that, okay, we got their attention, that this is serious, that we really need to get this job done. And they got a substantial amount of the remaining work done, but it still wasn't complete, and it started tapering off. They were there after a couple of weeks. They missed a couple of days. Nobody was there working all of a sudden. And then by the fourth week, they were there one day out of the fourth week, if I recall correctly. Basically, it just tapered off again to where they had finished roughly maybe 90% by the time they started back there, and maybe had 95% of the work done. And we're back to saying, come on, can we just get the last little bit of this work done so we can get to the city and get this approved by the city? And it dragged out through April and into May with them not quite finishing.
Okay, and did you ultimately send them a second termination that was a final termination?
Yes, that came after a meeting with Travis and Bob Kemp, their attorney on site, and Matthew Kruger with THB as well. Ted Reeder and I were there. There were 5 of us all together walking it, saying, here's all the last things that need to get done, and they said, okay, yeah, we can get this done within a week. I said, okay, if you can get this done within a week, you will get it done. Otherwise, you're finished, and we're going to hire somebody else to do the work. That was on June 2nd. On June 11th, I think is the date, or either June 10th or June 11th is the date I sent the letter terminating THB. And even in the meanwhile, I had emailed both Bob Kemp and Travis saying,
just a second. So
yeah.
He's being really non-responsive here, but I do have a quick question. So the first termination was 3/23/2000. Is that right?
Yes.
Correct.
That's
2020.
Exhibit 94. And the second termination letter was when?
June 11th, and I'm going to show. I was just about to show it, and it is Exhibit 98.
Okay. Are you almost done? I was going to take a break.
Let's take a break. Well, let me get through this letter, and then it'll be a good natural spot.
Okay.
Okay, Mr. Reeder.
Yes.
So you referenced a letter. Is this the June 11th termination letter? It's actually an email.
Yes, that's it.
Okay, and as of that date, you terminated them effectively and finally.
Yes.
Okay. And you specifically reserve your right to request damages related to a number of things, including the tree back charges, delay costs, and additional costs in completing the project that otherwise THB should have incurred, correct?
Right. Yes.
Okay. Let's go ahead and take a break, Your Honor.
Okay. Reconvene in 10 minutes.